Today we are going to discuss the weakness of the League of Nations in the context of minority rights. To start with, the formation of the League of Nations on 10th January 1920 was considered to have provided an experience of a first kind towards an organized international diplomacy among nations. The League was expected to erase bitterness between power blocs and nations, while at the same time giving a boost to the aspiring communities whose demands for political recognition was increasingly put on the platter of international relations. In the previous lecture, we have already discussed about the question of minority rights before the League and its aftermath. Today, we are going to discuss how the League actually suffered from several internal maladies. The victorious Allies left behind bitter memories of war suppression amongst the vanquished, that is, Axis power. The Treaty of Versailles is a case in point. The main focus of this lecture is to discuss how the horrifying experience of the World War I resulted in the increasing complexity of the world politics, particularly in dealing with the weaker aspects of addressing minority rights vis-à-vis the League of Nations. We can discuss about the foundational challenges. To begin with the foundational challenges, the origin of League is credited to Wilsonian 14 points framework, which suffered from various shortcomings. The framework which the League adopted could not properly differentiate between national self-determination and popular sovereignty. The juxtaposition of the two led to future unsettlement of minority rights that started to take the form of national self-determination movements. Among the initial challenges that the League faced include: number one, evolving a general framework of protecting minorities. Second, negotiating with minorities proved to be difficult due to various political choices between the host state and asserting minorities. Third, aspirations of the minorities often challenged the then status quo of the states. And fourth, the effective application of League principles on minority rights were often subjected to violation and non-cooperation by the powerful member states of League. Let us also discuss about the weaker areas of the League while looking at the experiences unfolded at the level of League's covenant, organs, committees, and dominance of powerful states. The Article 1 of the Covenant lays down the criteria for membership. In principle, League's membership was open to all, whereas the Covenant segments the status of members into two particular groups. There was a group of signatory powerful member states on the one hand, and self-governing countries including the dominions and colonies on the other hand. To continue the discussion on the Covenant, the Article 4 and 5 of the Covenant empowered the League to take decision on minority rights. The Article 4 and 5 suffered from a serious flaw as to arrive at a conclusive dealing of minority rights was controversially subjected to accused states' right to vote on such matters. The right to vote on such matters by the accused state hugely sabotaged the prospects of minorities achieving their political goals, particularly in the cases where powerful states were involved as accused states. Unanimity of decision-making on ensuring rights of minorities turned out to be a baffling matter within the League. To talk about the Article 10, Article 10 lays down the guidelines for respecting and preserving against territorial integrity of member states of League. The power to issue an advice on not to breach the non-aggression on members was with the Executive Council, which was consisted of the United States, the Great Britain, France, Italy, Japan, and other 4 nations. As the Article 10 empowered the Executive Council, it was the superpowers which enjoyed an upper hand in this regard. According to Article 11, I quote, "Any war or threat of war is a matter of concern to the whole League, and the League shall take action that may safeguard peace." Unquote. Ironically, conflict between states was something the League found most difficult to handle. The Article 11, Clause 2 and 13 also suffered from vagueness and ineffectiveness, since the term friendly right given to the member states to bring to the attention of the Assembly or of the Council. The term friendly right is a strange term that did not carry much political weightage as far as the rights of the minorities and weaker states were concerned. Again, the Article 22 was considered to have provided a wide room for resurgence of the formerly colonized states and minorities. However, the practical aspect was subject to several difficulties, as the advanced nations were to enjoy tutelage over such states and minorities on behalf of the League. The Article 22 failed to take up the issue of decolonization at the League's level. The status of mandatory enjoyed by the so-called advanced states over the lesser developed states equally created a complex regime of hegemony in the name of inability to stand independently by the colonized states. Under the aegis of the Article 22, the Central African states were also governed in similar ways while sustaining European imperialism in the world. To talk about the weaknesses of the organs of the League, we can say that the Executive Council and the Permanent Court of International Justice, also known as PCIJ, constituted the 2 most important organs that directly dealt with the issue of minority rights. The Council created an appeal system to address minority issues. The system allowed the minorities to appeal and to register their grievances directly to the PCIJ. What is interesting in this regard is that the League suffered from structural ineffectiveness. The option to send direct appeal to the Permanent Court was not availed to the minorities. The overwhelming power of the Council to recommend or to refer cases of minorities to PCIJ gave the Council member states an elite status. Despite commendable headway made by the League in envisioning minority rights, it remained structurally entangled. The demands from minorities to allow sending of direct appeals to PCIJ remain unsettled for many years to come. Let us discuss about the flaws in the committee system. In order to address the challenges confronted by the League to address minority-related issues, several committees were formed. The Committee on New States was one of the important committees empowered with 2 important privileges. The committee had the power to decide if a case was to send to the Executive Council. The other power was to even completely drop a case of minority question as either lacking political weight or legitimacy. The minorities felt manipulated by the host or accused state. The work of the committee was also hampered largely due to the apathy shown by the member states, as they wanted to refrain themselves from going on to respect minorities as prospective sovereign political units. The great powers argued that a generalized system on minority rights would be a dead letter in most countries. In this regard, the Executive Council appointed its Italian representative Tommaso Titoni. His report was presented in October 1920. Titoni's report brought out the right of calling attention to any infringement or danger of infringement of the treaty should not be prerogative solely of the states represented on the Council, but should be extended to the minorities themselves and even states not represented in the Council. Countries singled out and cornered by the great powers for the special restrictions of the league system bitterly resented what they viewed as a violation of sovereign equality and affront to their status as independent and sovereign. Now we are going to talk about problems in the petition system. The petition system can be regarded as a special measure designed to ensure the ability of minorities in terms of language, religion, and culture. Moreover, associations formed by minorities were on many occasions declared capable of exercising the right of petition. The League of Nations protection regime superimposed some elements of collective rights to moderate majority-minority tensions. The petition system came as a ray of hope for minorities in Europe to register their political grievances, although the petition system suffered from several limitations as the petition process was subject to stiff terms and conditions, which include the following. Number 1, petition were to be compatible with the minority treaties. Number 2, petition cannot primarily ask for severing relations with the state it inhabits. 3, petition needed to pass a difficult authenticity test by the Council. And number 4, minority movements in no case could resort to violent means and languages. Now let us discuss about some hard facts of League's failure. To start with, let us examine some important cases where the League failed to work. Number 1, there was a war between Russia and Poland between 1920 and 1921. In 1920, Poland invaded land held by the Russians. The Poles quickly overwhelmed the Russian army and made a swift advance into Russia. By 1920, the Russians had no choice but to sign the Treaty of RUHR, which handed over to Poland nearly 80,000 square kilometers of Russian land. The League hardly addressed the violation of rights of a country by Poland. To talk about the second case, that is the invasion of the RUHR in 1923. The Treaty of Versailles had ordered Weimar Germany to pay reparations for war damages. This could either be paid in money or in kind, that is, goods to the value of a set amount. In 1922, the Germans failed to pay an installment. In 1923, contrary to the League rules, the French and the Belgium invaded the RUHR, Germany's most important industrial zone, in which the League did nothing. And to talk about the third case, there was a conflict between Italy and Albania in 1923. The border between Italy and Albania was far from clear, and the Treaty of Versailles had never really addressed this issue. It was a constant source of irritation between both nations, which the League failed to address. Towards the conclusion on the topic, we can say that the League was never free from complicated power scramble among the hegemonic powers. The dead end of the League became evident as in the wake of the Great Depression of 1929. In the face of unstable political economy of the world, the League became ineffective to address minority questions. Powerful members of the League were not fundamentally supportive of minority issues. It was also exasperating that the great powers on the Council, particularly Germany after joining the League in 1923 and at once obtaining a permanent seat on the Council, could put items on the Council agenda regarding the protection of minorities without bothering about the petition procedures. Similarly, in September 1934, Poland denounced its minority treaty on the ground that it had caused inequality between states and refused to cooperate with international organizations like League of Nations on minority protection. The intervention of the League began to sound more like an ad hoc system. For political reasons, it was obviously going to be difficult for the League to enforce its views. In such an environment, violation of League's principles were often overlooked in order to get host states' cooperation. To conclude, it can be argued that the failure to translate rights of minorities into an easy practice is a historical challenge that we continue to find resonance even today.